Hi everyone. Can you hear me? You can hear me? Could be a little bit louder, maybe. Can you hear? That's better, I think. Okay. Thank you so much for coming and welcome to CryptoParty. I just would like to give a very quick introduction. I'm Silkie Carlo. I'm from Big Brother Watch, a privacy campaign organisation. We organise CryptoParty every month, as some of you know, because some of you have been before. I recognise you. And if this is your first time, then welcome. CryptoParty is a decentralised movement to offer free digital privacy training to people all over the world. And in particular, we often find ourselves giving digital privacy training to campaigners and activists. And you might ask why campaigners and activists aren't particularly dangerous people. They're people that want to try and make the world better. But as I think the discussion will unravel a bit tonight, campaigners and activists often do find themselves the subject of disproportionate surveillance and police monitoring, and often have their activities disrupted. So privacy is a particular issue. And I'm really, really delighted to be joined by two incredible speakers who I hope you'll hear a lot more from them than from me. We have Kevin Blowe, who's the Co-ordinator of NetPol. NetPol is a coalition monitoring and resisting excessive, intimidating and violent policing. So keeping an eye and challenging things like kettling, surveillance of protesters, stop and search, and excessive sentencing. Recently, NetPol has launched a campaign against the police, terming campaign activities as domestic extremism. And there was a fantastic letter, I hope you've seen, that was published in The Guardian that Kevin brought together over 150 academics, journalists, lawyers, campaign groups like Big Brother Watch, to stand against this and join our voices together to say that lawful campaigners shouldn't be termed domestic extremists. It's a step in the wrong direction. So we're going to talk a little bit about that. The other fantastic speaker that we have is Shamik Dutta, who is a human rights lawyer and an expert on all things privacy and data protection and surveillance, among many other topics. I expect that many of you support Liberty's challenge against the Investigatory Powers Act. It's something that we talk about every month. So I know that lots of you do. You can thank Shamik for a lot of the work on that case, because he's Liberty's solicitor, bringing that challenge. And he also he represented John Catt, who is a peace campaigner who was monitored and labelled by the police as a domestic extremist. And that was a really long legal battle that Shamik was directly involved with. I take a lot of the credit for winning that case, which sets a really important landmark for everyone, and he will explain why. So first of all, and after this, we will open up to questions and ask them anything. And then around 8:15, we'll start having workshops, digital privacy training. You can go up to anyone with one of these badges and ask us something about how to protect your communications, social media use, anything that's going to be helpful to you to protect your privacy online. And at the back, we have Mark, who's waving. And he's got a specially designed workshop on anonymity on social media, which is an increasingly important issue for campaigners and activists who are doing a lot of organising online. So that's going to be a really interesting workshop. Okay, without further ado, I want to kick off the discussion. I want to start by asking Kevin, can you just tell us a bit about your campaign around domestic extremism and protest and why it's so needed?
So thanks for inviting me here. The reason why we've launched our campaign is because over the last 5 years we've repeatedly come across examples where the police have been labelling campaigners as domestic extremists. And what I want to do, actually, if it's okay with you, can I ask that Shamik talks a little bit about the John Catt case first, and then let me make more sense? Yeah, let me just hand you over. Shamik, do you want to go?
Is this working? Is that working? Yep. Okay, great. Well, thanks everyone for coming. It's good to be in a room full of people who understand the importance of their own personal data and the importance of keeping it private, and also what the state can do with that information when it gets its hand on it. I think John's case is a prime example of what can happen when we have an overbearing state intent on gathering information on as many people as possible and as much information about them as possible. The detriment that can be caused to our rights to privacy, but also to free expression and protest. So I thought I'd start by just giving a bit of background about John himself. As you may know, I'm not sure how many of you are aware of the case, but John is now 94 years old, and he's been a protester and activist since the age of 17 when he fought in the Second World War. He was consigned to barracks for protesting in the Second World War about the poor rations that they faced. After that, he came back to London and was very involved in the anti-racist movement, and because of the horrors he'd seen in the Second World War, is a peace campaigner, so is an anti-arms trade campaigner. Now, John spent most of his life protesting, and what he would also do, he'd often go to a demonstration and he'd sketch what he can see. So he's an artist, he would sketch the scene and put his works on display. So far, so good. Why would anyone on behalf of the state be interested in someone who, by the time he met me, was about 80 years old? Well, 10 years ago, John came in to see me and said, essentially, I've been noticing that the police, wherever I go, are kind of following me around. And it's a bit weird, actually. I mean, I'm just there protesting and I'm sketching the scene that I see. And yet, recently, when I was driving through London, I was pulled over by the police. And he was pulled over in 2005, initially, by the police, while driving through London, and he said, "Why are you pulling me over?" And the police officer said, "Well, your car went under an automatic number plate recognition camera, and that showed that you had a flag on your car, an anti-terrorism flag." And he said, "Well, I don't know what that's all about." And they said, "Well, we have to stop you under the Terrorism Act and search you." So they did, and obviously found nothing. After that, he then realised he was being followed around at a Labour Party conference, at a TUC demo, and also attending demonstrations against the arms company EDO, which was involved in selling arms involved in the West Bank, in Palestine. And so, as a result of all this, he realised that something was wrong. Police officers were following him around, but he didn't actually realise why. And so his case has been marked by obfuscation by the police and the state at every single stage. The first stage was actually finding out what the police held about him and who it was that was holding that information. At around the same time as he was noticing this was happening to him, a police officer at a demonstration had dropped a spotter card. And that spotter card had photographs of various different protesters and also one of my other clients, the comedian and activist Mark Thomas. And on that were individuals who it was clear the police took an interest in. And so journalists were starting to look at this. Two journalists in particular, Rob Evans and Paul Lewis. They started writing stories about what this database was that might exist, which protesters may be on, and why the police were following peaceful activists around and why they were gathering information about them. And through them, John then decided, well, actually, maybe I should try and find out what's held about me. So he wrote to the Association of Chief Police Officers, which was an address that he was given by Greater Manchester Police, actually. So far, before he's even met me, he's found out that Sussex Police have got information about him and Greater Manchester Police have got information about him. So there's two different police forces in different parts of the country. He writes to ACPO, and his first letter is returned to sender, but he persists, and he writes back and says, "I'm pretty sure you've got information about me, please can you disclose it?" And ultimately, he is disclosed with 66 data entries, all about his movements. Now, it was detailed to the extent of quite often talking about what he was wearing, who he was with, the protests he was attending, so information about his appearance, his age, his friends, his political opinions and activities. So John instructs me to pursue a legal challenge in relation to this, and we initially send a letter to ACPO, which is a private limited company, the Association of Chief Police Officers, not even an actual police force, but a private limited company, which is chiefs of police at the time, advising on policy. And it transpires that they accept that they're holding this information about him, but they say it's lawful. They say, well, his privacy rights aren't engaged at all. He's doing all this in public. What's your problem? And obviously the problem is that the police are cataloguing and databasing an innocent person's activities, their political opinions, their appearance, and putting it on a clandestine database and labeling him a domestic extremist because that was the name of the database. So we challenged the retention of his information. By the time we got to court, there was also awareness of what was going on the part of other agencies. Her Majesty's Inspectorate of Constabulary had issued a report criticising the operation of this database and criticising the police data gathering like this. We got to the divisional court, and with any kind of legal challenge dealing with privacy rights under Article 8, you first of all need to establish that your rights have been interfered with, because that's an interference with Article 8. And the next thing you need to do is establish that that's unlawful, because there's no lawful justification for it. And the way the state will try and justify it is by saying it's in accordance with the law. And by that I mean that there is a system of laws which are in place. Everyone knows what's happening to them. No one's complaining about it. They all know where to go if they want to get the information. They know how to get their names off databases. And the next is the state needs to establish that it's necessary and proportionate for a legitimate aim, for example, fighting crime. In the divisional court, the court ruled that John's privacy rights were not even engaged. They said, what you're doing is in public, and therefore there's no reason at all for you to be concerned about this. You're doing it in public. People around you know what you're doing, and therefore it's fine for the police to gather information about you. And our argument was this: all of us, as we go through our day-to-day lives, are subjected to various intrusions into our privacy. There are certain interferences. If you walk down the road, you're filmed by CCTV. Now, all of us know that that information is not, if you're filmed by a shop CCTV camera, linked to your name, put on a database, searchable by hundreds of police officers around the country and possibly the security services, not subject to facial recognition cameras, and is not retained potentially indefinitely. And that's where the illegality is, we argued. That, yes, of course, walking around in public, there may be occasions when you're filmed, there may be occasions when other people see what you're doing, but it's the cataloguing and databasing of your information for potentially indefinite periods in circumstances where you don't even know what the databases are. You're categorized as a domestic extremist. You don't know how you get on the database. You don't know how to get off the database. All of this is the stuff of nightmares. It's the stuff of totalitarian regimes, and it's how you begin that slip into fascism, where you have the state being all-knowing and all-seeing, being able to catalogue and categorize political opponents as domestic extremists and target them, whether that be for preventing them to protest and stopping them from going to a protest, or potentially journalists and politicians. Now, in the course of John's case, we discovered that John obviously wasn't the only person who was subjected to this kind of monitoring. And what we found was that there are a number of other protesters who are on the domestic extremism database, but also a number of journalists who are on the database, and also politicians. A number of journalists, or members of the National Union of Journalists, who had spent their time reporting on police misconduct. So they would go to protests and they would report on police brutality, where police officers were committing potential offences. They would report on corporate misconduct, and a number of them realised that they were also on this same database. One photographer was categorised as an extreme left-wing photographer, whatever that means. So you see this kind of incipient expansion in surveillance, which includes not only activists, but also journalists, and also politicians. We discovered that the Green Party's Jenny Jones, who used to be the Deputy Mayor of London, was also on the database as well. So in the course of proceedings, we lost in the High Court, we asked the police to explain how many journalists, how many politicians, and how many people with no previous convictions whatsoever are on the database. And their response was, we can't tell you because we don't know. Now that in itself is troubling. If they're creating a database with that number of people and they're not even sure who is on it and don't have a system for weeding out people that shouldn't be on it at all, that in itself smacks of a system that's not working and not in accordance with the law. We appealed to the Court of Appeal, and having lost in the divisional court, we won in the Court of Appeal unanimously, with the court finding that it was disproportionate to keep information about John. And so we had won at that point. And then having won at that point, the police decided to appeal us to the Supreme Court. So we get to the Supreme Court, and we're met by a very hostile court. I remember the exchanges in court where the justices were saying things like, well, this isn't Stalinist Russia. The information isn't used for the persecution of dissidents. You've got to trust the police, haven't you? Let them get on with it. And this is all despite the fact that by now we know that undercover police officers have formed deceitful relationships with peaceful activists, fathering children quite often, without telling women who they were, that they were actually police officers. This is despite, by this point, knowing that union members had been blacklisted, and that there was a blacklist going around which was barring people from working. All of this information was known, and yet the Supreme Court decided that the mere retention of John's information, although they accepted that it interfered with his privacy rights, they said it was lawful for the police to gather this information for policing purposes. So John obviously immediately instructed me to issue an application in the European Court of Human Rights, and we did. And the reception in the European Court of Human Rights was very different. It was done on the papers, but we could tell from the questions that they asked straight away that they were more minded to find in our favour. And one of the reasons that I think this is, from my experience in working in privacy challenges, is a simple one. Members of the legal profession in this country, our society in this country, and that goes up to the judiciary, do not have a recent experience of totalitarianism. They haven't lived through the Stasi, they haven't lived through Nazism in this country, so they don't know and aren't mindful of, although they may know from reading history books, they may have seen it, they haven't lived through the experience of neighbours reporting on you and on the state gathering information on you simply because you're a political opponent and then using that to your detriment. So the European Court were in favour of our case and found in our favour. And the judgment was really damning on a number of respects. One of the things the European Court found was crucially that it wasn't necessary for the state to retain this information about John. The European Court commented on the fact that he hadn't committed offences, and that the justices in our country, in England, had ruled that this kind of interference was relatively minor, but they found that it wasn't, because of the nature of the information that was being held about him. The court was fiercely critical of the fact that this definition of domestic extremism was one that was subject to arbitrary redefinition over the years. It's something that Kevin, I think, will touch upon in a moment, but domestic extremism doesn't have a basis in statute. There is no law you can look at on the statute books which will tell you what a domestic extremist is. And so you end up with police forces changing the definition as years go by, essentially dependent upon justifying this big, massive information that they're gathering. And so it would change from time to time and subject to arbitrary redefinition. So you would never know whether you are classified as a domestic extremist, what you need to do to get onto the database, and what you need to do to get off the database. They criticised the fact that the courts here had not acknowledged that political opinions amount to sensitive personal data, as with union membership. And that sensitive personal data is called that because it requires added and enhanced safeguards. Can you imagine if Viktor Orban or Salvini, any of these countries around Europe where fascists are on the rise or in power, have access and are enabled by law to build a database of their political opponents? That is the first step to persecution, and the misuse of our data is and always has been the first step towards that kind of persecution. And the European Court was deeply critical of that, and two of the judges who issued concurring judgments, went further than the rest and said that the system in the UK was not in accordance with the law. Not only was the gathering of John's data unnecessary, but also it wasn't in accordance with the law. And so we have a great result now in the European Court. It's been a 10-year struggle, but finally we have the European Court finding that it wasn't necessary to retain John's data. The definition of domestic extremism is subject to arbitrary redefinition. Our political opinions are particularly sensitive information which needs to be kept private, and we have an entitlement to privacy over it. And a final thing they found was that the police forces here, part of their obfuscation had even involved not disclosing all of the information they held about John, even to the highest court in England and Wales, the Supreme Court. And of that they were fiercely critical, because they established essentially that this shows that whatever safeguards the police and the state may say they have, they're clearly not working. What we argued was that you can't have a system which relies upon whistleblowers and journalists in order to establish the existence of one of these secret databases. We all need to know what databases the state holds. We all need to know how we get off one of those databases. We all need to know on what basis the state might think we should be on one of these databases. Otherwise, you have a secret surveillance state, which is not democratic. So having won in the European Court, now the challenge moves back to the UK. And John's case is being relied upon in other challenges in relation to privacy. Challenges against facial recognition and a facial recognition database, the ongoing Liberty challenge against the Investigatory Powers Act, and hopefully it will be helpful in those challenges. What John's case shows is, in order to effect real change, you need to have not just a legal strategy, but also a political strategy, and you need to have the media reporting on it so that people are actually interested. And on that kind of political strategy and that campaigning strategy, I think I'll hand over to Kevin, who with NetPol is now taking the lead on that campaign.
Right, I'm going to try and get through. I'm not actually feeling very well, so hopefully I won't be turning pale and staggering off the stage again anytime soon. So just to very quickly talk about a little bit about the domestic extremism campaign. I've been on the database now 3 times, I think. The most recent was in 2012. And the reason why people end up on the database is the key thing to remember. It's not just anybody. It is people that are involved in some form of political challenge to the state or to corporate interests. People who are involved in some form of direct action. People who are seen as whose campaigning is needed to be delegitimized by the police. One of the things that we're trying to do is to say that the Catt case, what's crucial about it is that it's a turning point, that it's no longer possible for the police to be able to argue that they're constantly looking at the definition of what constitutes domestic extremism. The fact that they've been found to be acting unlawfully is the moment where we have to say that no longer can the police be allowed to use that definition at all. We certainly are also looking for gathering evidence and stories of particular instances where people have been targeted by counter-terrorism police. Recent examples include the police collecting information about some of the young people who have been involved in the climate strike. I'm going to have to stop again. I'm sorry. I'll answer questions in a bit, but I need to just step away. Hang on.
No worries. Thank you so much. And the campaign that Kevin's doing is absolutely fantastic. It's been so powerful already. So given where you've got to with the Catt challenge and the precedent that it sets, obviously that's one man's battle. What do you think is procedurally, what do you think needs to happen for there to not be a domestic... Do you envisage there not being a domestic extremism database at all, or just not a politicised one? What do you think?
Is it working? Yeah. It's a good question. I think that we've already very recently had support from the former independent reviewer of terrorism legislation, Lord Anderson QC, who had recently also commented upon the inadequate definition of domestic extremism. So I think that one thing that will have to change inevitably is this phrase that has been used to mask all types of unnecessary data gathering in relation to people who really are absolutely no threat to anybody and shouldn't be on a state database. So that is certainly one thing that ought to change. I think another thing that the European Court were critical on was the fact that this information could be retained indefinitely. That all that John could know is that the information about him was held for at least 6 years, and it could be held for much longer than that. So I think those two things are definitely ripe for change, and many more as well. I think that, broadly speaking, there does need to be a separation between the police's counter-terrorism powers and its units and those which police public order, because it's simply a world apart from each other to have someone who is interested in politics, who is expressing an opinion on climate crisis, or whether that be on workers' rights or Brexit. You know, if someone is expressing a political opinion in public, how dare the state treat them with the same language and the same kind of intrusive surveillance practices as they would someone who would be defined as a terrorist? It's inconceivable, and it's not something that I think can be lawful and would withstand the CAT judgment, not just in the UK, but also hopefully around Europe.
Definitely, from Big Brother Watch's perspective, we think any database, especially such a politicised database, that collects information on people that doesn't have, as domestic extremists, without having any definition of what that actually is clearly a political targeting and a free-for-all for abuse, and that's been evidenced. The question that I think the policy solution is quite straightforward. The legal issues are clear. I think the question that's really tough, that a lot of people struggle with, is why? Why do police bother? Why do they waste their time and resources doing this, collecting this information and monitoring people? Why did they bother putting John Catt on an ANPR watch list and searching him under the Terrorism Act? I think a lot of people think there must be something. There must be some kind of risk to this 90-year-old man. But we can see journalists on the watch list, campaigners, comedians, Baroness Jenny Jones, a really massive diversity of people on the watch list. That question of why is really difficult to answer. Do you have any insight or instinct about that?
Yeah, absolutely. I mean, turning back to John, the Supreme Court themselves, even the judges who found against us and against John in the Supreme Court described him as a benign spirit for whom the prospect of criminality is a very remote prospect indeed. He's a peaceful campaigner. What it seems like was happening, and what the European Court criticised as well, is that essentially you would have police officers who are tasked to police a protest, and they would film everyone, and they would make notes on everybody. And instead of those notes then being destroyed once it was clear that no offences had been committed at that demonstration, they would think, well, we've got this information, let's just put it on a database and let's build this database. And what would happen is that they ended up creating a beast that ultimately they argued was so big that it would make it difficult for them to now take off people they weren't interested in. And one of their actual arguments was, essentially, we've created this monster and now we can't control it. It's going to be too much effort for us to take people off the database. And the Strasbourg court were critical of that, and they said that you can't use as a justification for an invasion of privacy, an ongoing invasion of privacy, the fact that you've been so invasive in the past. There's no justification to carry on doing it. So I think, in answer to your question as to the nature of the people on the database, yes, there are journalists, politicians, activists who are not involved in criminality, and it was a case of information gathering, this dragnet being sent out to just gather as much as possible. And since we've got it written down, let's put it on a database because we've got it now, and maybe it's going to be useful in the future. And that idea of maybe it might be useful in the future The Supreme Court even referred to as the jigsaw effect, that you have a jigsaw and one piece of information is one part of the jigsaw, but it's only if you gather all the pieces of that and put them together that you might find something. Well, that would suggest that every single one of us would be happy to live in a democracy, which wouldn't really be a democracy anymore if you knew that every one of your movements and everything you're doing was tracked on the off chance that one day you might drive at 35 miles an hour in a 30-mile-an-hour zone. It just doesn't really make sense at all. But that was essentially the justification.
It's a case of mission creep, and it's not necessarily deliberate. The growth of the domestic extremism database as we know it.
I wouldn't want to get into the minds of the people who are involved in creating this database. I wouldn't want to do that, and it's not my job to do that. I think it's up to them to justify why they've done it. What's certainly clear is that despite it being apparent that the people have no intelligence interest whatsoever, the police continued defending their conduct. And that, I think, does tell a story of intent. Because it's one thing to say that a database has been built up over many years by people who are frontline officers who are going off making notes and then being told by supervisors, well, you better keep a record of it. It's quite another thing to, once that's been exposed, to fight tooth and nail through every single court in this country and in the European court to justify it, because it would have enabled a vast expansion on what was considered to be lawful in terms of state data gathering.
I completely agree, by the way, but it's just a question that always fascinates me, is why do police waste their time spying on earth-loving vegetarians? This is a complete waste of time and money, and makes campaigners like us really upset. Another question I wanted to ask you is about your experience with clients and subject access requests. How much can we trust them? We're in a case at the moment with Baroness Jenny Jones challenging facial recognition. I've spoken to some of you about it before. In her case, she was classed as a domestic extremist, and she was informed by a police whistleblower that some of her files had been shredded. And I think there are lots of people who are campaigners and activists who have similar experiences. I know I've done a subject access request, despite having been followed, filmed, had my house searched, all sorts by police. They came back with we have no records whatsoever. Lots of people have similar stories. Can we trust subject access requests to actually give us more insight into the domestic extremism database anymore?
I think it's very difficult to be able to have trust in that process because it has failed on so many occasions. What people quite often find is they'll have a response which says, we are giving you all that we are legally obliged to give you, words to that effect. But they won't say exactly what they hold and whether they hold anything at all. Now, there was a time when the police were more open in their responses, and that's what led to John, although there was a lot of obfuscation and secrecy in relation to him, ultimately he did manage, after a couple of attempts, to get hold of information about him. And other people have done likewise around that time period. I think post the Supreme Court judgment in Catt, we found, I've certainly heard from people that it seems to be going in the opposite direction, that there was more secrecy because the police felt that they could keep more secret. Now, that's in relation to intent. The other issue is just pure disorganisation. And I don't know if you saw, but today the Information Commissioner's Office has issued an enforcement notice against the Metropolitan Police because of its failure to comply with its own obligation under the Data Protection Act. And they've been ordered, just today, they've been ordered to respond to all of their outstanding requests, which are in the thousands, by the 30th of September 2019. So we may well see now certainly more efficiency because the ICO has shown its teeth. The extent to which information that's held about people is properly disclosed, it remains to be seen, the extent to which it will be. But I would certainly encourage anyone to make that request because you won't know unless you ask. And John wouldn't have known unless he had asked. Many of the people who are on the database, the journalists that I'm representing as well, they wouldn't have known unless they had asked the question. So it's definitely a good idea to ask the question and then to see where that goes and where that train goes.
Yeah. One of the things I'm really interested about that is that I suppose a lot of the stuff that's come back from subject access requests so far has been about grassroots activists doing street actions, direct action, and I really wonder what this looks like now and what political monitoring looks like now in the online sphere. And correct me if I'm wrong, but we haven't really heard much about police records on people, especially through subject access requests, since around 2012. But I assume that this kind of monitoring still goes on and there's more of it online, but we don't have people coming forward saying, I'm one of those people, really from the last kind of just under 10 years. Yeah. Do you have any thoughts about that?
As I say, I think that the post the Catt judgment in the Supreme Court, there does seem to have been a greater proportion of people coming to me saying, I've had a negative response or an obfuscatory response, which I can't make head nor tail of, and I don't know whether the police hold anything about me or not. So I think that did possibly embolden police forces not to release information, and I think that has to change now. Yeah, it has to change. But
it's digital, electronic and online monitoring that I'm really interested as well, given that especially that now even people who are organising street actions and building networks, is often a lot of it is online, God forbid, a lot of it's on Facebook. And this is creating real problems for people, I think, because they... The surveillance work is pretty much done. I mean, if you're organising your protest on Facebook and everyone's clicked attending, then, you know, you've created your own database. But that brings me on to the next question I wanted to ask you, and then we'll open up to questions from you guys. Given your work on the Investigatory Powers Act, I know there are lots of campaigners who are worried about how this new raft of powers could be used against them. I know it's a massive piece of legislation. We worked on it together. It's very complex. But what do you, in your opinion, do you think there is a real risk of IPA powers being used against campaigners to intercept, monitor people's organisation?
I think there is. I think there is not only that risk, but even before you get to that point, the very existence of the Act has a chilling effect on the exercise of free speech rights. It has a chilling effect because if you can't be sure whether what you're writing in an email is going to be subject to interference, then you will be more guarded in what you say. And the very free exchange of ideas and thoughts is what makes this a democracy, or what should make it a democracy. Not only that, but also the extensive hacking powers that exist mean that we are in a situation where you don't even need to have communicated something for it to be subject to that kind of interference. And in court this week, one of our barristers, our legal team on that is Martin Chamberlain QC, Ben Jaffe QC and David Heaton, who've been fantastic. And one of the arguments and one of the phrases that really encapsulated the interference that can take place with hacking was this: it's the difference between what you think and what you say to somebody else. And the fact that now with hacking powers, the state could obtain information about what you are thinking. You know, if you make a note on your phone, if you create a digital record, even if you choose not to communicate it with anyone, that is something that can be interfered with. And that is really pernicious and something that needs to be guarded against.
Yeah, completely agree, and that's why we're offering this training as well, to try and free up our ability to think freely and speak freely by giving you a bit of a privacy shield in your communications and organisations. So like I say, stick around afterwards and ask anyone with a badge or mark over at the back for advice about your digital privacy.